Judge Anthony Caldwell peers down from the bench at Officers Harris and McLean. The same men who shoved him onto asphalt last night now shuffle under his calm gaze. I know you both, he says evenly, removing his glasses. Maybe next time, check my credentials before slapping on handcuffs. Before we plunge into this gripping tale of justice and accountability, drop a comment with where you're tuning in from. Smash that like button and subscribe if you believe fairness under the law isn't negotiable. Now let's uncover how Judge Caldwell found himself delivering this moment of reckoning. Anthony Caldwell hadn't anticipated trouble that Tuesday evening. At 49 years old, the respected Philadelphia judge had spent hours at Jefferson Hospital, keeping vigil by his mother's bedside after open heart surgery. Only once doctors assured him she was stable did Anthony step away, his body weary, yet relieved by encouraging news. He dressed casually for the long hospital wait, dark jeans, worn sneakers, and a gray hoodie. The clothes felt unusual for a man accustomed to tailored suits, but comfort trumped formality tonight. Driving home, he stopped for gas at SoCo Station on Roosevelt Boulevard in suburban Abington Township, predominantly white. He vaguely recalled hearing about robberies plaguing convenience stores nearby, but gave it little thought as he swiped his card at pump number 4. Fluorescent lights bathed the nearly empty lot in harsh brightness. As he pumped fuel, his mind lingered on his mother's recovery, not the shadows surrounding him. That's when a police cruiser crept along the station's perimeter like a predator. Inside sat Officers Daniel Harris and Kyle McLean, both white men in their early 30s with rigid postures and buzz cuts. Praised for aggressive policing, their arrest statistics topped precinct charts despite mounting community complaints dismissed by internal review. Harris nudged McLean, pointing at Caldwell. Matches last week's Wawa's suspect, he muttered. McLean squinted. Black male, medium build, hood up. Fits the description. The vague profile could have matched thousands. Yet they swung their patrol car behind Caldwell's BMW, blocking him in. Anthony sensed trouble as they approached cautiously armed. He'd presided over countless cases echoing this moment, read the reports, heard the testimonies. Now the gavel of experience fell on him. Breathing deep, he steadied his voice. Evening, officers, he said, screwing his gas cap closed. Problem? Harris stepped forward, stance wide. Suspicious activity reported. Care to explain yourself? The question was absurd given his actions, but Caldwell knew the tactic. Just filling up after visiting my mother at the hospital, he explained evenly. Let's see some ID, Harris demanded. Anthony kept calm. Why? I'm simply getting gas. Harris's tone sharpened. You resemble a robbery suspect? ID. Now Anthony arched a brow. And the description beyond black male. His challenge irritated them. McLean stepped closer. Comply, sir, immediately. Knowing the danger, Anthony lifted his hand slowly. I'm reaching for my wallet. My name is Anthony Caldwell, judge of the Philadelphia County Court of Common Pleas. Harris scoffed. Sure, and I'm governor, he sneered. Before Anthony could pull his wallet, Harris yanked his arm, slamming him against cold steel. Pain shot through him as McLean hovered with hand near weapon. Stop resisting, Harris barked, though Caldwell remained still. I'm not resisting, he replied, cuffs biting into his wrists. My judicial ID is in my wallet, Caldwell insisted. We'll verify downtown, McLean dismissed, rifling through his pockets. A young white woman nearby filmed the scene. He's just getting gas, she called. Ma'am, step back, McLean ordered. Mr. Ramesh Desai, the South Asian night manager, rushed out, alarmed. Officers, I know this man, Desai pleaded. He's a regular, a judge. Harris barked back. Return inside or face obstruction. Caldwell caught Desai's eye. Call Angela Nguyen at the courthouse. Tell her what's happening. Desai nodded nervously as Harris shoved Caldwell toward the cruiser, pressing his head down indignantly. Phones recorded the humiliating image, a respected judge forced into the back of a squad car like a criminal. You're making a grave mistake, Caldwell warned. They all say that, McLean replied flatly, driving off. In the rear view, Anthony watched his BMW shrink, dignity fading with each passing street lamp. The station loomed close, yet every second stretched endlessly. The cuffs dug into his skin, echoing powerlessness. From the front seat, Harris chuckled. Another one claiming importance? Last week, some guy swore he was the mayor's cousin. McLean snorted. Remember the woman who said neurosurgeon? She had 3 warrants. Anthony sat silent, understanding words would be twisted. The station, a squat brick structure under glaring lights, radiated cold bureaucracy. Pulling into a rear spot, the officers dragged him inside. Determined, Caldwell straightened his spine. He'd seen countless defendants stripped of humanity here. Now he joined them in indignity. The booking sergeant, heavyset and jaded, barely glanced up. Gas station loiter, Fitzwawa suspect, Harris declared. Claims he's a judge. Nearby officers chuckled. Name? The sergeant asked. Anthony Caldwell, he replied firmly. Judge, Philadelphia County Court of Common Pleas. I demand my phone call. The sergeant scoffed, unimpressed. Empty your pockets, the sergeant ordered. Caldwell refused. First my call, as is my right. Irritated, the sergeant rose. It'll go smoother if you cooperate. Empty them, still cuffed, Anthony gestured. I cannot while restrained. I know my rights. Harris removed the cuffs roughly. There! Now do as told. Anthony placed belongings methodically. Wallet, keys, phone, hospital receipt, mints. The sergeant examined his wallet, flipping through cards, ignoring the judicial ID. Belt and shoes, he ordered. Caldwell complied, socks pressing cold tile. Each removed item chipped away at dignity. He thought of defendants who endured this silently, lacking his knowledge. A younger officer entered with coffee, pausing mid-step. His eyes widened. Judge Caldwell, he asked cautiously. Silence fell. Anthony recognized him vaguely. Yes, officer? Luis Morales, sir. You lectured at the academy last year on constitutional arrests. Uneasy, Morales glanced around. Is everything okay here? The sergeant's demeanor shifted instantly. You know him? The sergeant asked. Morales nodded. Absolutely. He's a judge. I attended his lecture on arrest procedures and constitutional protections. The irony hung heavy in the air. The sergeant studied the judicial ID more closely, unease creeping onto his face. Morales leaned in, whispering urgently into his ear. The sergeant stiffened, picking up his phone. Captain, booking. You'd better come down here. Now. Within minutes, the mood flipped. Authority scrambled where arrogance had ruled. Captain Robert O'Donnell stormed in, tall, polished, hair flecked with gray. His face froze at the sight of Caldwell, shock mixed with dread and recognition. The captain's presence stilled the room. For Harrison McLean, swagger drained to silence. Caldwell stood firm, shoulders squared despite bare feet on cold tile. The irony of lecturing young officers on rights only to be denied his own was bitter, yet the reckoning ahead promised something larger than himself. Every officer's eyes flickered between captain and judge, uncertainty replacing mockery. Caldwell didn't need to speak. The weight of his presence filled the room. What began as humiliation was shifting toward accountability, though the scars of that night, physical and otherwise, would not fade easily. The gavel of justice was turning. Behind clenched professionalism, Caldwell thought of his mother, unaware her son had been caged in chains. He thought of defendants he doubted, realizing tonight mirrored their testimonies. Each second underscored the dangers of profiling, arrogance, unchecked power. He remained steady, but inside, fury simmered. A judge transformed into the judged. The captain's jaw tightened as he reviewed the ID himself. Judge Caldwell, he said finally, voice grave. The room stiffened. This shouldn't have happened. Harris shifted uneasily, McLean's face pale. Caldwell met their eyes, calm but unyielding. Yet it did, he replied. His words cut sharper than any courtroom gavel. O'Donnell's polished veneer faltered. He ordered Harris and McLean aside, the booking sergeant silent now. Anthony gathered himself, dignity partially restored, but damage already done. Phones still recorded outside. Witnesses would speak. Tonight's humiliation would echo beyond these walls, forcing a community to confront uncomfortable truths about power and prejudice. Anthony stood tall, shoeless on sterile floors, as officers fumbled around him. Morales lingered close, a quiet ally in a hostile room. The balance had shifted. Arrogance now weighed with consequence. Caldwell knew the fight wasn't just for him, it was for every person denied dignity in this place. The thought burned clear. How many stood powerless here without recognition, their pleas dismissed, their rights delayed, until forgotten? Anthony was fortunate. Connections, authority, reputation. Others weren't. Tonight exposed cracks not only in police procedure, but in the justice system itself. And this reckoning, Caldwell realized, was only beginning. Morales' loyalty cut through tension. His acknowledgement cracked the facade of denial. The sergeant's earlier contempt gave way to embarrassed compliance. O'Donnell pressed lips thin, calculating fallout. Caldwell said nothing, silence sharper than reprimand. For Harris and McLean, the weight of exposure grew unbearable, their reputations now permanently shadowed. The irony was undeniable. Caldwell had taught Morales the principles these officers ignored. To see them undone by their own disregard for law illuminated the divide between practice and principle. Anthony's steady composure contrasted their unraveling confidence. Justice wasn't abstract anymore. It stood barefoot in booking, demanding recognition in real time. And in that charged silence, as the captain whispered orders and officers avoided his gaze, Anthony Caldwell understood this night would reshape more than his own reputation. It would ripple outward, challenging a system blind to its bias. The reckoning had arrived, not from the bench, but from the booking room. Judge Caldwell, Captain O'Donnell greeted, his voice suddenly syrupy with forced warmth. Seems we've had a terrible misunderstanding. Anthony met his eyes coolly. Indeed, Captain, a misunderstanding of rights, procedure, and dignity. The captain's smile slipped. Let's get your belongings returned immediately. Coffee, perhaps? No, Caldwell replied. I'd prefer protocol. O'Donnell nodded quickly. Of course. You may use my private line. Caldwell shook his head. The booking phone is sufficient. I don't seek special treatment. The subtle sting in his tone made the captain wince. As Caldwell approached the phone, Harris and McLean were summoned into the captain's office, already gesturing defensively. Through the glass, Anthony observed them constructing their defense, frantic hands cutting the air. They weren't searching for truth, they were manufacturing a story to protect themselves and the department. Picking up the receiver, Caldwell dialed not an attorney, but colleague Judge Angela Nguyen, who specialized in misconduct. His words stayed measured, deliberate. As he explained the ordeal, Officer Luis Morales lingered close, visibly conflicted, torn between loyalty to his badge and respect for Caldwell. Around the station, whispers grew. Officers who had mocked him now cast furtive glances, voices low. The sergeant, once dismissive, pounded his keyboard feverishly, documenting every detail to shield himself. Inside O'Donnell's office, tensions flared. McLean's arms folded tight, Harris pointing aggressively, their captain rubbing his forehead while muttering into a phone. By the time Caldwell ended his call, his items had been gathered in a plastic bag. Belt and shoes returned, the sterile ritual of dignity restoration unfolded without apology. Captain O'Donnell reemerged, wearing his professional smile, though strain flickered in his eyes. Judge Caldwell, please accept my apologies. Officers Harris and McLean were simply vigilant, responding to local robberies. Caldwell accepted his belongings, but not the excuse. Vigilance doesn't excuse violations, Captain. You know a vague description is not probable cause. The captain's grin tightened. In the heat of the moment's split-second decisions, Caldwell interrupted. And those decisions carry consequences. His voice was steady, unyielding. I will not sign statements or waivers. I expect an unaltered incident report. Before O'Donnell could respond, Morales approached. Sir, your car remains at SoCo. I'll drive you. Anthony nodded, gratitude flickering for the young officer's integrity. As they headed toward the exit, his phone buzzed with alerts. Videos from the gas station had already hit social media. Faces blurred, voices sharp. The arrest of a sitting judge. By morning, the city would know. Harris and McLean's world was shifting. Stepping outside, Caldwell inhaled crisp night air. Dignity intact, faith shaken, he sensed tomorrow's storm building. Sometimes justice arrived unexpectedly. At his Chestnut Hill colonial, Morales dropped him off. Porch lights glowed in silence. Mrs. Abernathy, walking her terrier, paused mid-step, staring at his disheveled appearance with thinly veiled surprise. Anthony raised a hand in greeting, aware of the image. A black man, tired, rumpled. Arriving late in a wealthy white neighborhood, would she call the police, labeling him suspicious in his own driveway? The thought clenched his stomach. His key turned in the lock. Warmth enveloped him, though unease lingered. The scent of Vanessa's candles filled the air, vanilla and cinnamon, yet home felt altered. Dad! Jalen, his 18-year-old son, rushed in, phone glowing. Behind him, 15-year-old Zora stood pale, eyes wide. We saw the video, Jalen said, his voice laced with anger. It's everywhere. Anthony dropped his bag and pulled them close. Vanessa emerged, sharp-eyed, concern in her stance. Are you hurt? She asked, scanning him head to toe. Physically, no, he answered truthfully. They gathered in the living room. The muted news replayed grainy footage of his arrest under the caption, Philadelphia judge detained at gas station. His family clung tighter. We'll file emergency injunctive relief tomorrow, Vanessa said, legal instincts engaged. Civil rights suit by noon. I'll call Michael at the ACLU. Anthony shook his head. Not yet, her brow furrowed. They assaulted a judge. This is clear profiling. Public outrage is peaking. Caldwell's gaze shifted to his children, their faces tight with fear. He saw their innocence cracked by reality. Remember the talk we had when you started driving? He asked Jalen. His son nodded. Hands visible, no sudden moves. Yes, sir. No, sir. Ask before reaching. Zora whispered softly. Always get their badge numbers. Anthony's chest constricted. I followed all of it tonight, he said. I was polite. I identified myself, moved carefully. Still, it didn't matter. Zora leaned against him. Because they didn't see a judge, she murmured. They saw a black man. Caldwell nodded. And that was enough. His phone buzzed again. Chief Justice Richard Hartman was calling. He excused himself, retreating into his office. Anthony, I just saw the footage, Hartman began without preamble. This is outrageous. I've already contacted the commissioner and mayor. They promise a full investigation. Thank you, Richard, Caldwell replied, sinking into his chair. I appreciate it. Take time off. I'll reassign your cases. Caldwell hesitated. No, I'll keep tomorrow's docket. A pause on the line. Are you sure? No one would fault you for stepping aside. Caldwell's voice steadied. I'm sure. Now more than ever, I need to be on that bench. After the call, he opened his laptop. The video was viral, hundreds of thousands of views. Analysts debated across channels. His inbox flooded. Interviews, solidarity messages. Then his phone rang again. His mother, still hospitalized, had seen the news. Anthony, are you safe? Her frail voice trembled. I'm fine, Mom. Focus on recovery. Don't tell me not to worry, she scolded faintly. I marched for civil rights before you were born. Nothing's changed. No, some things haven't, he admitted softly. After reassuring her, he sat in darkness, surrounded by framed milestones, degrees, rulings, photos with community leaders. His judicial oath hung above his desk, suddenly heavier, almost hollow. He reached for law books, searching precedent, wrestling with questions of recusal and responsibility. Pages whispered. Vanessa entered quietly, tea in hand. The kids are finally asleep, she murmured, setting it beside him. Jalen wanted to stay up, help build a case. Anthony smiled faintly. Like mother, like son. She perched on his desk. What's your plan, Anthony? I know that look. He turned his laptop. Tomorrow's docket, he said. Judge Sanderson was assigned a misconduct hearing involving Abington officers. Vanessa scanned the screen, eyes widening. The same precinct as Harris and McLean. Anthony nodded. Sanderson called out sick. Guess who's next in rotation? Realization dawned, her expression darkening. The conflict of interest. I've researched precedents, he cut in. There's no automatic recusal here. The matters are technically separate. Technically, Vanessa stressed. You know the union will fight it. Caldwell's jaw tightened. Let them. For once, let the system prove itself. Midnight neared. He finally headed upstairs, showering away sweat, but not memory. The water-stung bruises blooming along his arms. In the mirror, dark marks testified to Harris's grip. He touched them, the sting both physical and symbolic. As a judge, he'd heard countless testimonies of abuse. Had he truly believed them all? Somewhere along the climb to authority, had he drifted from the realities endured by those without power? He remembered Howard University days, youthful fire to reform the system from within. Tonight rekindled that fire with painful clarity. Now he faced a choice, shield himself from conflict or stand firm as justice's embodiment. What would you do in his place? Recuse to preserve neutrality or confront injustice directly? Comment number 1 if you believe Judge Caldwell should step aside, avoiding appearance of bias. Comment number 2 if you think he should seize this chance to hold the system accountable. Tomorrow, in a Philadelphia courtroom, that choice will collide with history, and the echoes of tonight will resound. The story does not end with bruises fading or videos trending. It presses forward to chambers, to families, to city halls where accountability is demanded. For Anthony Caldwell, the coming hours were not just about justice for himself, but for every voice silenced by the very system sworn to protect them. Tonight's ordeal carved scars beyond the physical. Yet, as dawn approached, resolve crystallized. Justice could no longer be academic, it had to be lived. From the gas station's pavement to the courthouse bench, Caldwell's journey became a reckoning. And in that reckoning, the measure of a judge and a system would be tested. With his robe waiting in chambers, with eyes of a city turning toward him, Judge Caldwell stood at a crossroads. Neutrality had its place, but so did courage. Tomorrow, the bench would not just hear arguments, it would deliver a message. The only question was, how loud would that message be? As the clock neared midnight, Anthony finally slipped beneath warm sheets beside Vanessa. But sleep eluded him. His mind replayed each second, the cuffs, the disbelief, the humiliation. Yet beneath it all pulsed a steady truth. Silence protected no one. Tomorrow he would speak, not as victim, but as judge. Bruises mottled his skin, proof of Harris's heavy hand. But they were more than wounds, they were testimony. Each mark echoed the voices he'd once doubted, now seared into his own flesh. The question remained, would he carry them into the courtroom as scars alone, or wield them as instruments of justice? What would you do if you were Judge Caldwell? Would you recuse yourself, preserving impartiality, or use your authority to confront systemic abuse head on? Comment 1 if you'd step aside, 2 if you'd press forward. Tomorrow's decision won't just define him, it may redefine what justice means in America. Should preside over this hearing and hold these officers to account. Hit like if you've witnessed or experienced profiling, and subscribe to our community that fights for justice through storytelling. Now, let's see what Judge Anthony Caldwell chooses to do with this unexpected chance to confront systemic bias from the bench. Morning light stretched long across Philadelphia as officers Daniel Harris and Kyle McLean arrived at the precinct. Sleep had been scarce, not from remorse, but logistics. Would the judge incident trigger paperwork? Captain Robert O'Donnell had promised the usual. The department would close ranks. Administrative leave with pay, worst case. Still, the viral clip complicated everything. As they dressed, their phones buzzed in unison with a department-wide alert. All officers connected to pending misconduct matters report to Philadelphia County Courthouse, courtroom 4B, 10 a.m., mandatory. McLean shot Harris a look. That's us on the Johnson complaint, right? Harris buttoned his shirt. Routine hearing, Harris said. Judge Sanderson usually takes the department's view. A sergeant stuck his head into the locker room. Harris, McLean, Captain wants you before you head to court. In O'Donnell's office, the captain looked unusually taut, hands arranging papers that didn't need arranging, voice trimmed to managerial reassurance. Just a formality, he promised, straightening another neat stack. Johnson's complaint is baseless. He resisted. You followed protocol. The officers nodded. They'd danced this dance before. Complaint, internal review, exoneration. The system functioned as designed. O'Donnell continued. Answer directly. Stick to the report. Emphasize your training. McLean risked the real question. What about last night, the judge? O'Donnell waved it off. Handled at the commissioner's level. Entirely separate. As they left, Harris elbowed McLean. Maybe we'll see the Your Honor filing his little grievance? They chuckled, oblivious to the stage awaiting them across town. And who would be seated at its center? Across Philadelphia, Judge Caldwell entered via the private judicial entrance. The security team, old colleagues, were unusually solicitous. Good to see you, Judge, said Leon Jackson, the senior guard. Saw the news. Shameful Caldwell nodded thanks and continued to chambers, where silence hung heavier than usual around the black robe on its hook. A knock cut through his thoughts. Judge Angela Nguyen stepped in without waiting, closing the door firmly. You should have called the moment they pulled you over, she said. A formidable jurist and Caldwell's closest colleague, Nguyen, didn't waste words. I hear you're taking Sanderson's docket this morning. Caldwell adjusted files. Food poisoning, apparently, he said, including the Abington Township misconduct matter. Nguyen folded her arms. Anthony, the appearance of conflict. Considered, he interjected. I reviewed the ethics canons. No technical requirement to recuse technical, she echoed, just like Vanessa had. The union will explode. Caldwell met her gaze, unblinking. Angela, when was the last time an officer faced real consequences in your courtroom, or mine? She didn't answer immediately. Statistics answered for her. Misconduct findings rarely translated into meaningful discipline. You're walking a tightrope, she said. I know, he replied, but sometimes justice requires it. She paused, then nodded once. I'll be in courtroom 3A if you need backup, Nguyen said, hand on the knob. She turned back. For what it's worth, I think you're right. Just be careful. After she left, Caldwell's clerk entered with the morning's files. Abington case has last-minute filings, Your Honor, and unusual media interest. Thank you, Sophia. Coordinate with security, Caldwell said. He opened the file. Antoine Johnson, 24, a black motorist alleging racial profiling and excessive force during a traffic stop. Named officers, Daniel Harris and Kyle McLean. A cold recognition rippled through him, the same men who'd cuffed him 14 hours ago. He reviewed Internal Affairs' conclusion, predictable exoneration, despite witness statements supporting Johnson. Personnel records showed 5 prior complaints against Harris and 7 against McLean, all dismissed or unfounded. The pattern was obvious to anyone willing to see it. A knock announced Sandra Whitman, the district attorney assigned to police misconduct matters. Whitman entered cautiously, expression telegraphing regret. Good morning, Judge Caldwell. About today's hearing. You're here about recusal, he said evenly. She nodded, clearly uncomfortable. Given last night, the department questions impartiality. Caldwell gestured to the open cannons on his desk. I've reviewed ethics thoroughly. No absolute requirement to recuse here. This matter involves different facts and parties, he continued. But the same officers, Whitman interjected, and the same precinct. Indeed, Caldwell said, which gives useful insight into practices. He stood, concluding the meeting. I'll hear your motion in open court, Ms. Whitman. Court convenes at 10. She left. The clock ticked louder. He donned the robe. It had always signified order and respect. Today it felt like armor. He lifted the files and stepped into the corridor. Murmurs tapered as he passed. Clerks, attorneys, even officers measuring him with the new gravity history had fastened to his shoulders overnight. He kept walking. Outside courtroom 4B, a crowd had formed. Reporters with press badges, community organizers with buttons, union officers in starch blues. Caldwell nodded to the bailiff, who swung open the heavy doors. Inside the gallery was packed beyond capacity. Antoine Johnson sat with his public defender at one table, jaw set. At the other, Harris and McLean conferred with their union lawyer, backs to the door. The bailiff's cry rose. All rise! The Court of Common Pleas for Philadelphia County is now in session. The Honorable Anthony Caldwell presiding. As Caldwell ascended, recognition slashed across the officers' faces like sudden blinding light. Harris froze mid-sentence, mouth slightly open. Color drained from McLean's cheeks as he glanced at counsel in panic. Their union attorney looked puzzled, then connected name to headline. Caldwell settled at the bench, aligning papers with practiced calm, while electricity prickled the air like static before a storm's first strike. Be seated, he said, voice steady. The tension didn't release. It merely sat. Caldwell looked directly at Harris and McLean, the same men who'd pressed his face to cold metal. Good morning. We are here on Johnson versus Abington Township Police Department, alleging misconduct and excessive force. He let the tableau breathe. Before proceeding, I acknowledge recognizing officers Harris and McLean from a personal encounter last night, now public. Whispers erupted, quick and sharp. The union attorney sprang up. Your Honor, we request immediate recusal. Caldwell had anticipated the move. Your objection is noted. I'll hear formal argument shortly. He turned to Johnson. Mr. Johnson, are you prepared to go forward today? Johnson glanced at his public defender, then nodded. Yes, Your Honor. Caldwell faced the room. Justice must not only be done, it must be seen to be done. The threshold question is whether I can be impartial. I believe I can, but I will hear arguments to the contrary. He nodded at the union lawyer. Counselor, present your motion. Harris and McLean whispered urgently, their swagger replaced by desperation. Caldwell recognized the look. He'd seen it countless times. Sudden awareness that choices do not dissolve in paperwork. Some actions bring consequences eventually. The union attorney, Maxwell Gordon, approached confidently, silver hair and precision tailoring projecting authority. Even so, the morning's twist had rattled him. Your Honor, he began, voice calm but tight, given your personal interaction with my clients yesterday evening, these proceedings are stained by the potential for bias. The gallery stilled. Judicial Canon 3 demands recusal where impartiality might reasonably be questioned, Gordon continued. The appearance of impropriety alone compels withdrawal. Moreover, your personal knowledge of disputed facts concerning these officers creates an insurmountable conflict. He paused, satisfied. Caldwell turned to the defense table. Miss Rivera, your response to the motion? Gabriela Rivera rose, department store suit, scuffed briefcase, her presence more grit than gloss. Your Honor, we oppose recusal. The incident involving the court and these officers is distinct from our case's facts. If relevant experience alone disqualified judges, no veteran of criminal law could ever preside over criminal matters. That's untenable, she added carefully. Context regarding officer conduct can enlighten, not contaminate, judicial evaluation. The law does not command retreat from knowledge. It commands fairness. Caldwell inclined his head. Thank you, counselor. He turned to the prosecution. Miss, Whitman, as the Commonwealth, your position? Every eye swung toward the DA's table. Whitman rose reluctantly. The Commonwealth takes no position on recusal, Your Honor. We defer to the court's judgment on ethical questions. The neutrality was a shield. Caldwell recognized institutional caution when he saw it. He took a breath, not to decide, he'd already decided, but to mark the gravity of announcing it. Motion for recusal is denied, Caldwell said, voice firm. A gasp rippled through the gallery. Gordon surged back to the lectern. Your Honor, unprecedented, given your personal involvement. Caldwell lifted a hand. Mr. Ramacci, Gordon, you will be heard on the merits, but the canons require reasonable doubt of impartiality, not mere conjecture. This court is capable of separating public controversy from evidentiary evaluation, he continued. My obligation is to apply law to facts, in plain sight. Denial stands. We will proceed. He looked to Rivera. Call your first witness when ready. Outside, cameras waited. Inside, the gavel of accountability hovered over every word. Caldwell glanced at Johnson, then at the officers whose confidence had curdled into dread. We will build our record transparently, he said. If there is misconduct, it will be named. If there is none, it will be declared. He nodded to the clerk. Mark Commonwealth in defense exhibits accordingly. Proceed. Sandra Whitman sat, eyes fixed on her notes, saying nothing further. Her office's caution was telling. Caldwell folded his hands. Counsel, this court will tolerate no grandstanding. We are here for facts, not theater. Begin. The room leaned forward together, the city's heartbeat sinking with the slow, relentless cadence of testimony. Mr. Gordon, let me be plain, Judge Anthony Caldwell said. Blind justice means impartiality, not ignorance. Experience doesn't disqualify a judge. It can illuminate policing practices directly at issue. He leaned forward. Our tradition does not demand recusal, merely because a judge possesses relevant knowledge of the world. By your logic, Caldwell continued, a judge harmed by malpractice could never hear malpractice, or a judge who witnessed discrimination could never preside over discrimination claims. The room stayed hushed. My oath requires justice without respect to persons, he said. It does not require justice without respect to reality. I can separate personal experience from the specific facts, he concluded. Gordon braced to object, but Caldwell pressed on. Your objection is preserved for the record, counselor. We proceed. He turned. Miss Rivera, call your first witness. Rivera nodded crisply. The complainant calls Antoine Johnson. The young man approached, jaw tight. After swearing in, Johnson sat, hands clasped, eyes flicking between the bench and the officers. Rivera began. Mr. Johnson, describe your encounter with Officers Harris and McLean on March 14th. Johnson breathed in. I was driving home from my hospital night shift. I'm a nursing assistant, when I noticed a squad car following. It was around 11:30, Johnson said. I wasn't speeding. They followed 5 blocks, then lit me up. He described the stated reason, a broken taillight. Mechanics records later showed the light worked perfectly. Caldwell noted familiar hallmarks, vague pretext, immediate hostility, escalation when a citizen calmly questioned authorities' basis for intrusion. They asked where I was coming from, where I was headed, Johnson continued. When I asked why I'd been stopped, Officer Harris told me to stop being difficult. They ordered me out, said they smelled marijuana. He shook his head. I don't use drugs. I agreed to a search after they explained the stop. What happened next? Rivera asked. Officer McLean grabbed my arm, pulled me out, Johnson said, voice tightening. They slammed me on the hood, cuffed me. Harris kept yelling. I was resisting. I wasn't. They searched, found nothing, but still charged me with resisting and obstruction. His words hung like a bruise in air. Rivera called a bystander who'd filmed part of the incident. The cell phone video showed Johnson standing calmly as cuffs clicked, flatly contradicting the officer report describing aggressive, uncooperative behavior. Then two earlier complainants, both black men, recounted nearly identical encounters, flimsy pretexts, rapid escalation, force, then charges later dismissed. During these testimonies, officers Harris and McLean grew visibly uneasy, whispering constantly to Maxwell Gordon, whose confidence ebbed. Rivera introduced body camera footage from Johnson's stop. The images showed Johnson compliant while officer tone sharpened. Abruptly, the feed died, right as the supposed aggression began. A too familiar phenomenon blinked into silence. The camera malfunctioned at that exact moment, Rivera said dryly. Convenient, someone whispered from the gallery. Caldwell shot a look, restoring order. The pattern, malfunctions during critical escalation, was notorious in policing circles. Gordon objected repeatedly, but momentum shifted. Caldwell ruled scrupulously, granting where warranted, overruling where not. Impartiality etched into each syllable. Just before lunch, an unexpected figure slipped into the back row. Mr. Ramesh Desai, night manager of the Soko station from the prior evening. During recess, he approached de Rivera, showing something on his phone. When court reconvened, Rivera rose. Your Honor, an additional witness has come forward with relevant evidence. Caldwell arched a brow. Proceed, Counselor. We call Ramesh Desai, Rivera announced. Desai took the oath, hands trembling slightly. After confirming his role as Soko's manager, Rivera asked, Do officers Harris and McLean frequent your station? Yes, Desai said, almost nightly. Have you observed their interactions with customers? Many times, Desai answered. They often question black and brown customers, especially young men, asking why they're there. It's a gas station. They're buying gas. Gordon sprang up. Irrelevant and prejudicial. Rivera countered. It establishes pattern and practice, directly relevant to whether Mr. Johnson's stop was isolated or systemic, Caldwell considered. Objection overruled. The witness may continue, he said. Desai swallowed. After what happened to you, Judge, I checked our security archives. We retained footage 14 days for insurance Rivera approached with a laptop. Your Honor, Mr. Desai has provided Soko security video from March 14th, the night Mr. Johnson was stopped. Caldwell sensed the gallery hold its collective breath. Rivera narrated. The footage shows officers Harris and McLean at Soko roughly an hour before the stop, discussing their plan to make numbers. Gordon leapt. Objection. Non-disclosed evidence. Rivera replied, He came forward today. Defense could have requested local security archives at any time Caldwell weighed the equities. Admitted conditionally, he ruled. Defense may review and challenge. The screen flickered. Harris and McLean appeared, uniforms casual, voices unmistakable. Need 1, 2 more stops to hit quota. Then McLean, let's sweep the South Side. Always good for numbers. Everyone knew the South Side was predominantly black and Latino. Caldwell watched the officers' faces more than the pixels. Harris stared at the floor. McLean whispered urgently to Gordon. The pattern of targeted enforcement was hardening into evidence beyond Johnson's case toward departmental culture. Gordon requested a brief recess. Caldwell granted it. The officers filed out. Confidence leached away. When they returned, Gordon announced they'd call Captain Robert O'Donnell to testify regarding policies. Sworn in, O'Donnell avoided eye contact with his officers. The strategy was obvious. Shift blame from individuals to institutional expectations. They didn't realize that door, once opened, permitted scrutiny of the entire house. Caldwell let it swing. On direct, O'Donnell delivered the practiced script. 27 years on the force, constitutional training, force continuum, community outreach. Our officers are thoroughly trained in de-escalation, he assured. The veneer gleamed under fluorescent lights until Rivera stood for cross. Notes minimal. Questions honed like chisels against a marble facade. Captain, do you use quotas for stops or arrests? Rivera asked. O'Donnell shifted. We have performance metrics, not quotas. Officers are expected to be proactive. How measured? Stops, arrests, activity levels are one factor, he admitted. And officers who don't meet activity benchmarks? His pause answered before his mouth did. Their evaluations may reflect lower initiative, O'Donnell conceded. Rivera nodded. So officers are incentivized to make stops regardless of constitutional predicate? Gordon objected. The damage was already done. The incentive structure was in the record. A culture that rewarded volume over validity had finally been named. Under oath, when Harris and McLean took the stand, their stories diverged immediately. Harris claimed Johnson reached toward his waistband. McLean insisted it was a sudden move to the glove box. Neither motion appeared in the surviving body cam footage, and neither had been included in their initial, supposedly contemporaneous incident report. Caldwell watched with clinical detachment. He'd seen this choreography before, post hoc justifications wobbling under precise questions. Officer Harris, he interjected during Gordon's direct, you stopped, mister. Johnson because his taillight was out, correct? Yes, Your Honor. Yet, the next morning inspection showed all lights functioning. How do you explain that discrepancy? Harris swallowed. It must have been repaired before inspection. Caldwell's brow lifted. And your report describes belligerence, but the available footage shows calm, compliant behavior. Explain, Harris said. He became aggressive after the camera malfunctioned. Caldwell noted the answer, voice even. How fortunate that malfunction occurred at the pivotal moment. Pens scratched. As questioning continued, McLean began to fray, answers halting, eyes darting to Harris or Gordon. Rivera pressed on the SoCo conversation. When you said you needed stops to hit numbers, what did you mean? McLean stammered. It's how we talk. It doesn't mean anything. So no intent to make pretext stops? It's complicated, McLean said finally. There's pressure to show results. Rivera's voice softened, blade hidden in velvet. Pressure from whom? McLean glanced at O'Donnell, then back at his hands. From supervision, from the department culture. Gordon hurried to redirect, but the admission already reverberated, heavy as a gavel finding wood. Caldwell marked the record carefully. Incentives, culture, conflicting narratives, missing footage at critical junctures, a pattern coalesced into more than coincidence. The gallery leaned forward, sensing a tide turn. Outside, headlines wrote themselves. Inside, the transcript grew teeth, each line a future exhibit in a fight larger than any single case. Rivera resumed. Officer Harris, did you document any odor of marijuana in your initial report? No, he conceded, but we smelled it. Yet your search yielded nothing, correct? Correct. And you charged resisting and obstruction after finding nothing? He nodded, voice small. The courtroom's oxygen thinned with each concession. Caldwell addressed him again. Officer, when you say resisting, do you mean verbal questioning of your commands? He was argumentative, Harris said. Argument is not resistance, Caldwell replied, tone neutral. The law allows citizens to ask the reason for a stop. That principle predates every badge in this room. Silence gathered. Rivera turned back to McLean. Your testimony differs from Officer Harris's on crucial details. Which version should the court accept? McLean's jaw worked. I remember the glove box, but not the waistband, Rivera said, and neither appears on video. McLean's answer withered. Caldwell wrote another line, ink steady, conclusions patient. Gordon attempted to steady the ship, objecting on form, on scope, on tone, anything to slow the unraveling. Caldwell sustained where proper, overruled where not, even-handed to a fault. Impartiality was not performance, it was practice. And practiced here, in full view, it became its own lesson in accountability. During a brief recess, a young officer slipped into court and whispered to Rivera. She listened, expression sharpening, then nodded once. When proceedings resumed, she rose with quiet purpose. Whatever had just been shared promised to reach beyond two officers toward the systems that trained them, graded them, and looked away. When proceedings resumed, Rivera rose with a new name. The complainant calls Officer Luis Morales. The young Latino officer who'd recognized Judge Caldwell at booking walked nervously to the stand. Sworn in, he glanced apologetically toward the defense table. Officer Morales, Rivera began, how long with Abington Township PD? 14 months, ma'am. During training, what were you taught about stops in certain neighborhoods? Morales hesitated. We were told to be extra vigilant in high crime areas. And how were those areas defined? Rivera asked. Morales shifted. Mostly the south and east sides, predominantly minority communities. Were you trained on reasonable suspicion standards? Officially, yes, he answered carefully. Unofficially, that's different. Unofficially, what, officer? Rivera pressed. Morales inhaled. Veterans told rookies that some behaviors signal suspicion, but the meaning changed depending on who and where. Same actions meant something different in certain neighborhoods or with certain people. Rivera nodded. Specifics, please. Morales's eyes lifted to the bench, gathering resolve before he continued. We were told, Morales said, voice steadying, that a black man driving a nice car in a white neighborhood was suspicious, that a young black male in a hoodie was inherently suspect, that furtive movements could be interpreted broadly. Gordon erupted in objection. Caldwell overruled. Direct experience in training is admissible, Proceed Morales continued. Officers Harris and McLean were seen as productive because they made lots of stops and arrests, mostly minorities. He swallowed. After Judge Caldwell was brought in last night, I heard Harris say they'd bagged another one before realizing who he was. A murmur rippled. Caldwell's expression didn't move. And after they realized the judge's identity? Rivera asked. Morales's answer cut the room. Captain Robert O'Donnell gathered everyone and said we needed to get our story straight because judges stick together. Dispatch was told to modify the call log to reflect a complaint about a suspicious person matching the judge's shock rolled outward. Evidence tampering hung like thunder. O'Donnell's face drained. As Morales finished, McLean sat rigid, clearly wrestling with himself. During the next short recess, he leaned into an intense sidebar with Gordon. When court reconvened, Gordon addressed the bench. Your Honor, Officer McLean requests a private conference with court and counsel. Caldwell considered, then nodded. We'll convene in chambers. Officer McLean, Ms. Rivera, Mr. Gordon, and the reporter only. In the quiet of chambers, McLean slumped. I need to clarify, he began haltingly. What I said earlier about pressure and culture, it's worse. Much worse. Gordon tried to interject. McLean continued. We're trained to lace reports with certain phrases, McLean said. Furtive movements matched the description. Appeared nervous. Code that papers over thin stops. He looked up at Caldwell. Last night with you, we had no real reason to approach except, Caldwell finished softly, except I was black at a gas station. McLean nodded miserably. That's how the culture works. Not official policy, but the message is clear. Be proactive in certain neighborhoods with certain people, and you're rewarded. His words didn't just implicate himself and Harris. They point upward toward supervisors, evaluations, a system built to favor numbers. By the time they returned to court, word spread that McLean was cooperating. Harris looked betrayed. O'Donnell's jaw clenched. Reading the moment, Dia Sandra Whitman requested a brief recess to reassess the Commonwealth's posture. In the gallery, community members whispered. Some had lived similar stories. Few had seen officers admit them. When proceedings resumed, the atmosphere, had shifted. Whitman stood. In light of new testimony, the Commonwealth is expanding its investigation to include departmental policies and potential criminal charges regarding evidence tampering. Gordon, seeing the defense crumble, asked for time to discuss settlement. Before Caldwell could rule, Harris abruptly rose, face flushed. This is, Harris exploded, anger cracking restraint. We were doing our jobs. If people would just comply, instead of making everything about race. Gordon hissed for silence. Harris barreled on. You all want special treatment. Even a judge thinks he's above the law. The courtroom froze as raw prejudice surfaced. McLean recoiled, sliding his chair away as if distance could cleanse the words. Caldwell allowed the outburst to hang, truth revealed in heat before speaking evenly. Officer Harris, that's enough. The room silenced instantly. Your comments are part of the record. He turned to the reporter. Please transcribe the statement in full. Caldwell faced Harris again, voice calm but flinty. People often reveal themselves under pressure. Thank you for your candor. The defense lay in tatters, yet the implications reached beyond these two officers. The hearing had become a mirror for a broader system, and the reflection was unflattering, unmistakable, and public. What began as one complaint now exposed a pattern. The pivot happened because two officers profiled the wrong black man at a gas station, and the city watched. Was McLean a whistleblower or a self-preservationist? The gallery wrestled with that question, even as Caldwell steered the courtroom back to evidence. The afternoon transformed into a systematic inquiry. Gordon objected repeatedly. Your Honor, this is about specific officers, not an indictment of a department. Caldwell's gaze was steady. When evidence suggests individual acts reflect institutional patterns, the court has the right and duty to examine those patterns. The public interest demands nothing less. With that ruling, the scope widened. Rivera called additional complainants whose accounts aligned, disproportionate stops of Black and Latino residents, vague matches a description, charges later dropped. A community analyst presented public record data showing minorities stopped at quintuple the rate of whites, even when controlling for crime rates and call volumes. Performance reviews told another story. Officers concentrating stops in minority neighborhoods scored higher and advanced faster. In majority white districts, articulable suspicion was strictly demanded. In minority areas, high crime zone became a catch-all. The data formed a lattice of discrimination that statistics couldn't launder and anecdotes alone couldn't fully prove. Until now. Media swelled outside. Inside, the gallery teemed with neighbors whose lives had intersected with flashing lights. Every statistic mapped to someone's night, someone's fear. Caldwell permitted expert testimony explaining how phrases like furtive movement masquerade as neutral while enabling bias. Dr. Eleanor Simmons called them coded levers of discretion with disparate impact. By mid-afternoon, Police Commissioner Frank Hargrove arrived, visibly rattled by the hearing's widening lens. During a recess, he asked for a private conversation. Caldwell refused. Any input from the commissioner must occur on the record. So Hargrove, tight-lipped, took the stand, an unusual tableau, swearing to policies he now had to defend. Our department rejects profiling, Hargrove said, discomfort plain. Policies prohibit using race in enforcement decisions. Rivera's cross was surgical. Commissioner, if policy forbids profiling, how do you explain persistent, statistically significant disparities after controlling for crime rates, calls, and deployment? Hargrove shifted. Multiple factors influence patterns. Rivera pressed. The disparities remained stubborn, measurable, unexcused. Outside, the crowd thickened, signs reading "Justice for All" and "End Racial Profiling." The case had outgrown one man's complaint. A note reached the bench. The mayor and council sought a meeting. Caldwell declined off-record discussions. Any engagement must be within the proceeding, he said. The courtroom, not back rooms, would decide. Another recess revealed familiar faces. Vanessa, Jalen, and Zora slipped into the back row. Their presence steadied Caldwell and sharpened stakes. This wasn't only about a judge or a complainant. It was about what kind of city his children would inherit, and whether the law could still be their shield. When court resumed, Morales returned to the stand. After my testimony, he said, several officers approached quietly. They want to speak about practices but fear retaliation. Ethical lines surfaced. These officers weren't parties, yet their accounts could clarify systemic truths. Rivera and Gordon argued fiercely over scope and protection. Caldwell weighed the dilemma, then ruled, "This court will hear testimony from willing officers under seal, with identities protected until appropriate whistleblower safeguards are in place." Gordon protested. Caldwell overruled. The search for truth must proceed. One by one, officers stepped forward, voices subdued, details crisp, shielded by anonymity and a restless conscience. 5 officers corroborated the architecture described by Morales and McLean. Unofficial quotas, evaluation metrics equating volume with valor, coded report language, a thin blue line expectation to close ranks, stops concentrated where residents had the least power to complain. Discretion, they admitted, tilted predictably, and supervisors rewarded those tilts. Statistics met testimony, culture met consequence. The transcript accumulated weight, enough perhaps to bend policy. Cameras hummed outside. Inside, the record grew meticulous teeth. Caldwell's pen moved deliberately. Whatever happened next, sunlight had reached corners long kept dim by convenience, fear, and the comforting fictions institutions tell themselves. The commissioner stared ahead, jaw tight. Gordon shuffled notes like talismans. Rivera pressed, unwavering. Caldwell kept the tempo. Orderly, unsparing, fair. This wasn't spectacle, it was civics. Law converted into daylight. The court had become a classroom where evidence taught, and the syllabus listed accountability as a required course. Caldwell scanned the packed room, neighbors, reporters, officers' family, then returned to the matter at hand. The record will reflect sealed testimony received, he said. Parties will receive redacted summaries consistent with protections. He glanced to counsel tables. We proceed to remaining witnesses and exhibits. The room exhaled, then leaned forward again. The search for truth must prevail, Caldwell reiterated. Voice even. Counsel. Call your next witness. Outside, chants lifted. Inside, the slow machinery of law turned, noiseless gears catching, then grinding forward. Whatever verdict awaited, the day had already rendered one finding unmistakable. Sunlight, once admitted, is difficult to dismiss. One sealed witness proved especially devastating. We were coached to use phrases courts routinely accept, he said. If a report says furtive movements or match the description, the stop almost always survives challenge, even with thin detail. The words landed like a blueprint for manufacturing legality, out of vagueness. As afternoon bled toward evening, disclosures kept arriving. Memos showed officers with the highest totals of stops and arrests earned plum assignments and faster promotions. The institution itself, it seemed, rewarded volume over validity, an incentive structure pushing aggressive tactics whether or not constitutional thresholds were actually met on the street. Recalled to the stand, Captain Robert O'Donnell conceded performance reviews tallied stops and arrests without a counterweight metric for constitutional compliance. We assume our officers follow the law, he offered weakly. Judge Anthony Caldwell replied evenly. And yet, there appears to be no systematic audit to verify that assumption, Captain. Non-District Attorney Sandra Whitman looked increasingly strained. Her office had built countless prosecutions atop stops, now appearing constitutionally brittle. Near day's end, she approached the bench. Your Honor, in light of today's testimony, the Commonwealth requests time to reevaluate procedures governing officer testimony and evidentiary practices in criminal matters, a significant concession. If the DA really tightened scrutiny, Hundreds of pending cases could wobble. The implications were finally escaping a single hearing's gravity, just as Caldwell intended. Sensing danger, Maxwell Gordon scrambled to narrow the blast radius with a proposal that sounded more like spin control than a remedy fashioned for the truth. Your Honor, Gordon said, my clients acknowledge mistakes in Mr. Johnson's matter and agree to prospective procedural revisions. Too little, too late. The record no longer described isolated errors, it mapped systemic design. Fixing forward without accounting backward would varnish symptoms while leaving causes intact. Caldwell's eyes telegraphed that reality. Addressing the room before adjournment, Caldwell said, what we've heard extends beyond two badges. Evidence suggests structural patterns implicating every citizen's rights. Tomorrow we'll take final argument and consider remedies, not only for Mr. Johnson's case, but for the broader concerns this record has surfaced. A hush answered, heavy with expectation. As people filtered out, Antoine Johnson stood with family, no longer just a complainant, but the reluctant fulcrum of a potential landmark. Responsibility sat plainly on his face, alongside something brighter. Agency. Across the aisle, Kyle McLean looked unburdened by truth. Daniel Harris kept his jaw clenched and gaze hard. Caldwell remained on the bench after the gallery emptied, annotating margins, stacking exhibits, replaying testimony. The day had vaulted from personal insult to public reckoning. Tomorrow's task would be harder still, shape consequences that punished wrongdoing, corrected incentives, and fortified the law without letting symbolism replace meaningful change. What began with humiliation on cold metal now opened a door to reform. Could one hearing alter deep habits, or would institutional gravity reassert itself, flattening momentum once cameras left? Caldwell knew rulings mattered, but pressure from beyond the bar would decide whether change stuck or merely skimmed the surface. Morning returned with chants on the courthouse steps. Signs read, Justice for Judge Caldwell, Reform Abington PD, Equal Protection. He entered through the judicial corridor, avoiding cameras, not the consequences. A private ordeal had become a public rallying point. The story no longer belonged to him, but to the city. In chambers, an ethical nod awaited. To conclude properly, Caldwell had to address his own encounter with Harris and McLean, yet he could not be both judge and witness. After phoning Chief Justice Richard Hartman, a narrow path emerged that honored procedure without burying the very facts at issue. Court convened. All rise. The Honorable Judge Angela Nguyen, presiding Nguyen, explained the temporary arrangement. She would hear Caldwell's testimony regarding his arrest. He would resume afterward. No back rooms, no shortcuts. Just a transparent pivot designed to keep faith with the law while confronting the truth head on. Caldwell laid his robe aside and took the stand as Anthony, not Your Honor. He described the gas station approach, the dismissal of his identification, the slam against steel, the cuffs, the deliberate delays at booking, until recognition flipped demeanor from contempt to contrition. The courtroom's stillness felt almost sentient. His account was careful, restrained, unmistakably human. Beyond the bruise of metal and bite of chain, he spoke of sudden invisibility, status erased in a glance, worth reduced to silhouette. When I hit that car, he said quietly, it felt like centuries pressed down beside the cold. Pen stopped moving. On direct by Gabriela Rivera, he was asked about impact. There's a deeper injury than bruises, he said. I've spent years trying to make the system protective by design, experiencing how easily it fails those it should shield. It unsettles your faith if you let it. I won't. Gordon's cross was restrained. Procedural clarifications, no attacks. The prior day had drained his appetite for combat. When Caldwell finished, he stepped away from the witness chair and returned to chambers while Judge Nguyen heard closings, ensuring the record contained argument untouched by the dual role his circumstances required. Rivera framed the evidence as architecture, not accident, incentives, metrics, language, culture. Gordon replied that mistakes could be addressed prospectively, cautioning against conflating anecdotes with policy. The contrast was stark. System versus slip up. The courtroom absorbed both stories, knowing full well which one better matched the day's exhibits. Caldwell resumed the bench. The court recognizes the unusual posture, he said. Serving as both subject and adjudicator raises fair concerns, but recusal now would strand these systemic issues outside any forum empowered to address them, merely because I experienced what many here have long alleged. Silence deepened, respectful. Throughout our legal history, he continued, judges are expected to set aside personal experience and decide on the record. That expectation applies with particular force today. This proceeding will be governed by evidence, not sentiment. The transcript, not headlines, will carry the weight of what we decide. He drew a measured breath. Before he could announce findings, Harris stood. Your Honor, may I address the court? The request startled many who'd heard his fury yesterday. Caldwell weighed the moment, then nodded. Harris approached slowly, posture smaller, voice quieter, the practiced certainty of patrol replaced by an unfamiliar and complicated restraint. I've been on the job 11 years, he said. My father and grandfather wore the badge. I believed I was doing what they taught me. He paused. Yesterday's testimony, I never saw the pattern. Each stop felt like a gut call. Maybe I was trained to see threat first. He looked up at Caldwell. When we stopped you, I didn't see a judge. I saw danger because that's how I'd learned to look. The gallery remained still. It wasn't absolution, but it was a first acknowledgement, a hairline fracture in a wall sustained by tradition, incentives, and denial. I'm responsible for my choices, Harris added, but it's bigger than me. How we're trained, how we're rewarded. He stepped back. Caldwell nodded once, neither praising nor condemning. The hardest task remained: craft accountability that punished harm, dislodged bad incentives, and invited change beyond a single headline's half-life. After a brief recess to finalize language, Caldwell returned with his ruling. He would write not only for the parties, but for those who would cite this transcript: officers, supervisors, prosecutors, defense counsel, future judges, and citizens who rarely see their daily realities reflected in the cold grammar of law. This court finds that officers Harris and McLean violated Mr. Johnson's constitutional rights through racial profiling and excessive force, he said. Further, the record supports that these violations reflect departmental patterns and practices rather than isolated misjudgments. The gallery held its breath. Even the HVAC seemed to hush in place. Remedies must address both individual accountability and structural reform, he continued. First, officers Harris and McLean are suspended without pay for 6 months and must complete intensive retraining in constitutional policing and implicit bias recognition as a condition of any return to duty. He turned toward the department representatives, voice steady. Second, Abington Township Police Department shall implement comprehensive reforms. Body-worn camera usage is mandatory, with civilian review of footage. Performance metrics must prioritize constitutional compliance over raw stop and arrest counts. All officers will receive continuing training with regular reassessment. Compliance will be monitored and reported publicly on a set schedule. Third, the court establishes a civilian oversight committee empowered to review complaints and recommend discipline, including community members from the most affected neighborhoods. He faced Antoine Johnson. Mr. Johnson is entitled to compensation for his unlawful detention and rights violations. The amount will be determined in subsequent proceedings. Fourth, given the record, all arrests by this department over the past 3 years predicated on vague criteria, such as matched a description or furtive movements, shall be reviewed for constitutional sufficiency. Across the room, shock met relief. The ruling reached backward and forward, refusing to treat symptoms without addressing cause. Reactions fractured. Community members shared cautious hope. Department officials looked grim. Already doing math. Johnson wiped at quiet tears, vindication finally tangible. McLean seemed relieved, as though truth had lightened a weight. Harris stared down, face pulled tight, meeting consequences for the first time without the shelter of euphemism. Caldwell closed with a message for courtroom and city alike. Accountability is the floor of justice, not the ceiling. Reform demands more than punishment. It demands transformed policies, practices, and perspectives. That work begins today. Its success depends on sustained commitment from everyone in this room long after these proceedings end. With a final rap of his gavel, Judge Anthony Caldwell adjourned. The hearing had ended, but its force had only begun to spread, from a single gas station encounter to a community's reckoning. Gathering his notes, he met Antoine Johnson's gaze. Understanding passed between them, quiet and resolute. History seemed to lean forward. Two black men who'd endured the same insult now shared something else, a rare chance to turn humiliation into reform. 6 months later, Caldwell stood at a podium inside Abington Township's community center, opening the inaugural session of the Police Accountability Commission he had been appointed to chair. The moment refused to fade. The auditorium overflowed, uniformed officers beside neighborhood advocates, city officials next to residents. When I accepted this role, Caldwell began, many doubted real change. Commissions have come and gone, issuing glossy reports that gather dust. He gestured toward the crowd. What makes this different is in this room, shared responsibility. People felt it. In 6 months, changes exceeded expectations. Every officer now wore body cameras that could not be manually disabled during citizen encounters, footage uploaded automatically to secure servers overseen by civilian reviewers. Stop data was analyzed each month for racial disparities, and the results were posted publicly, not buried in memos. Tomorrow felt nearer, most transformative. Evaluation criteria were rebuilt from the ground up. Officers were rewarded not for raw stop or arrest counts, but for constitutional compliance, community engagement, and de escalation success. Preliminary numbers show discretionary stops down 40%, Caldwell said, while crime rates remain steady or fall. Aggressive stop quotas never delivered safety resolve, traveled quietly. Front row sat Officer Luis Morales, newly promoted to lead the department's Community Relations Division. His honest testimony had been pivotal, and instead of ostracism, he'd earned respect. Behind him sat Officer Kyle McLean, back from suspension, mentoring rookies on constitutional policing and admitting past failures without hedging. It felt overdue and possible. Officer Daniel Harris's path was harder. His courtroom outburst had been followed by resistance in retraining. He nearly resigned, wrestling with new expectations. With unexpected support, including from Antoine Johnson, he began confronting bias directly. Tonight he sat quietly near the back, present but subdued, emblem of difficult, necessary personal change. Hands rose in agreement. Caldwell acknowledged individual journeys, then turned to institutions. We complied with every court order and went further. Training now explains not only what to do, but why it matters. Community voices shape policy at each step. Most importantly, officers are encouraged and protected when they report questionable conduct inside the ranks. The record would remember. He introduced a panel featuring Antoine Johnson, whose case sparked the overhaul. Johnson had used settlement funds to return to school, studying criminal justice with plans to work in policy. When I was pulled over, he told the crowd, I just wanted acknowledgement that what happened was wrong. The promise felt tangible. He glanced toward Caldwell. Acknowledgement is the beginning, not the finish line. Real justice requires action reform, radiated beyond protocols. The SoCo station where Caldwell was arrested became an unlikely community hub. Manager Ramesh Desai mounted a small plaque and offered free coffee during monthly dialogue circles with officers. Even skeptics paid attention. Caldwell's son, Jalen, was changed by everything that followed. Anger became engagement. He joined the Youth Advisory Council that consulted on training scenarios. College brochures on his desk ranged from pre law to criminal justice, and surprisingly, law enforcement, different paths toward the same mission of building something fairer than before. Trust moved inch by inch. The most important shift, Caldwell said, isn't only in charts, it's in small encounters, everyday moments where authority meets dignity. It's the traffic stop where rights are explained, not barked. It's the officer who sees a neighbor, not a target. It's a heartbeat that doesn't spike when blue lights appear. Tomorrow felt nearer. He shared a story from last week. At the same SoCo pumps, a young officer approached a stranded teen. The officer introduced himself, explained why he'd stopped, then asked how to help, not for identification. Unremarkable in a just world, quietly revolutionary in ours. Progress sometimes whispers before it sings. The room breathed again. Caldwell admitted the work was unfinished. Some officers clung to old habits. Some residents, scarred by years of harm, remained skeptical. Neighboring departments watched cautiously. Transformation isn't an event, he told them. It's a process, messy, incremental, stubbornly human. Heads nodded, hopeful, wary, because trust returns in steps, not leaps. New habits tried to form. 6 months ago, that gas station exposed deep fractures, he said. It also revealed our capacity to face hard truths and build better. He swept the room. The question was never perfection. The question is courage, whether we will keep examining ourselves and repairing what's broken. Murmurs answered, yes, try. Resolve traveled quietly. During open discussion, Caldwell stepped back from the microphone. Through the wide windows, he watched patrol cars roll through side streets less like occupying caravans, more like guardians. The feeling wasn't naive optimism, but something sturdier, disciplined hope, earned through policy, practice, and the willingness to be held accountable in public. The record would remember. That evening, he pulled into SoCo for gas. At the next pump, a young black man kept wary eyes on a uniformed officer inside the store, muscle memory of caution that still lingered. When the officer emerged and offered a respectful nod, something eased. Caldwell met the young man's glance. Acknowledgement. People felt it. He drove home, reflecting on a paradox. Change was real and incomplete. The system had been flawed before his arrest and remained imperfect after reforms, but it was better. In the work of justice, better is precious, evidence that effort matters, and reason to keep pushing when fatigue arrives. New habits tried to form. What do you think about Abington's changes? Is transformation possible within current frameworks, or do we need bolder redesigns? Comment with your thoughts. Like, subscribe, and share if this resonates. Your engagement helps hard conversations reach wider circles and keeps pressure on institutions to honor their promises beyond headlines. It mattered beyond symbolism. Thank you for staying with this story of accountability and the ongoing labor of fairness. It illustrates how a single incident can widen into reform when institutions are forced to look in the mirror. Caldwell's experience bridged doctrine and reality, turning abstract ideals into tasks that could not be postponed. Silence carried meaning tonight. His unusual role, both harmed and adjudicator, became a rare catalyst. Bias did not operate only in hearts, it lived in incentives, scripts, and unchecked discretion. The issue wasn't merely bad apples, but a barrel built to reward certain choices. Remedies had to reach culture, not just punish individuals. Hope grew more muscular. Change proved plural. McLean's candor, Morales' courage, and Harris's halting recognition showed different velocities toward the same horizon. Accountability opened paths to redemption without excusing harm. Communities needed protection and fairness. Officers needed standards and support. Reform asked everyone to change something: policies, habits, reflexes, and the stories we tell. Resolve traveled quietly. The narrative underscores a final truth: justice is process, not destination. It demands vigilance, participation, and humility. Real progress is more than new trainings, it's a shift in how we see one another. When power confronts its failures, healing becomes possible, not guaranteed, but finally within reach. Every witness had weight. Have you witnessed injustice and wished for leverage to change the rules? In Caldwell's place, would you have recused to avoid appearance concerns or used that perspective to push accountability forward? Share your view below. I read every comment. Your voice widens the circle and keeps momentum from dissipating. The moment refused to fade. If this story moved you, tap like so others can find it. Algorithms notice participation. Subscribe for more deep dive narratives exploring civil rights, public safety, and the ongoing project of a fair society. Share this with someone who needs to understand both the harm of profiling and the possibility of change. Tomorrow felt nearer. We aim to inform and challenge, entertainment with a conscience. These conversations aren't easy, but they're essential. Spotlighting the mechanics of bias invites accountability that slogans can't deliver. Keep the discussion going. Collective attention is a tool, and sustained focus shapes policy far more than one viral clip ever will. People felt it. Thank you for joining today. Remember, each of us holds a piece of this work. Voters, neighbors, officers, lawyers, judges, journalists, kids on their way to school. Justice can't remain abstract. It must be lived. Keep speaking truth to power, and keep building the habits that make fairness ordinary. Even skeptics paid attention. As Caldwell left the community center, evening settled over Abington. The street outside felt changed, not solved, but steadier. Patrol cars rolled past slowly. Porch lights flicked on. He thought of tomorrow's meetings, next month's audits, and the year after that. Reform survives in calendars, not headlines alone. Hands rose in agreement. Somewhere across town, a young driver exhaled when a cruiser glided by without lingering. Somewhere, an officer paused before writing match description, choosing specificity instead. Small decisions accumulate. The work continues. If these voices resonated, subscribe and share. Each signal helps carry this conversation where it matters into policy and practice. Resolve traveled quietly. For those of us who have lived long enough to see the seasons of America turn, there is a sobering truth that never grows old. Justice is not guaranteed. Many of you remember the civil rights marches of the 1960s, the images on black and white television sets, the voices of leaders echoing through the National Mall. You might recall the names of neighbors who suffered indignities simply for the color of their skin or the place they lived. The courtroom story of Judge Anthony Caldwell was a stark reminder that no matter how many decades pass, injustice can still strike, even against someone who wears the robe of a judge. Imagine the humiliation of being slammed against your own car, not because you committed a crime, but because of the shade of your skin and the neighborhood you happen to be in. That memory stays with a man, no matter his age or his accomplishments. And yet, in that pain lies a truth older Americans have always understood. We must keep fighting to defend the fragile promise of justice, or it slips through our fingers. Older generations know the cost of silence. You remember neighbors who kept their heads down, who hoped problems would pass if left unspoken. But silence rarely ends injustice. It only allows it to grow stronger. What made Caldwell's story different was not only his courage to stand up in court, but also the community's willingness to rally behind him. From the young nursing assistant Antoine Johnson, whose complaint began the case, to the South Asian gas station manager, to the Latino officer willing to testify, every voice mattered. Even the officer who once stood on the wrong side, Kyle McLean, chose to break ranks and tell the truth. It was the collaboration of many, not the heroics of one, that made reform possible. For older Americans who watched towns pull together after wars, natural disasters, and times of hardship, this is a lesson we know by heart. When neighbors link arms, change becomes real. And in today's fractured world, remembering that community is our strength may be the key to healing divisions. Those of us in our later years understand better than most that progress is rarely quick. You have seen leaders come and go, commissions form and dissolve, promises made and forgotten. Caldwell's commission, formed after the courtroom revelations, was different only because it refused to stop at words. Body cameras were installed that could not be turned off. Stop data was analyzed monthly and shared publicly, not hidden in filing cabinets. Promotions began to depend not on how many people were stopped, but on how respectfully officers treated the citizens they served. And in one remarkable scene, a simple moment at the gas station showed how far things had come. An officer introduced himself to a stranded black teenager and offered help instead of suspicion. That may not seem revolutionary to some, but for those who have lived through decades of strained police community relations, such an interaction was nothing short of extraordinary. Yet even Caldwell admitted that change was not complete. Some officers resisted, some residents remained skeptical, and older Americans, perhaps more than anyone else, know the long rhythm of reform. It takes persistence, patience, and determination across years, not days. Transformation is not a single chapter, it is the whole book, written line by people who refuse to give up. For a 65-year-old or older, this story is not just about today's headlines. It is about the kind of country we leave behind for our children and grandchildren. Many of you have marched, voted, prayed, and sacrificed so that those who came after you might inherit something better. Caldwell's ordeal reminds us that while progress is possible, it requires constant vigilance. The next generation is watching us, just as we once watched our elders. They will measure us not by the words we spoke, but by the courage we displayed when justice trembled. And so the lesson is clear. The fight for dignity never ends, but neither does the hope that binds us together. From gas stations to courthouses, from city streets to living rooms, America's story is still being written. And you, no matter your age, still hold the pen. Friends, after hearing Judge Caldwell's story and the hard earned lessons it revealed, I want to hear from you. Do you believe true transformation in policing can happen inside our current system? Or do we need to build something completely new? Think about your own experiences, times when you witnessed or even lived through injustice. How would you have responded in his shoes? Share your thoughts in the comments below. Don't forget to like this video, subscribe to the channel, and spread it with friends so we can keep these powerful conversations alive and growing.